Thank you for joining this overview presentation of the New Brunswick Office of the Rentalsman. The agenda of this presentation contains 6 topics that will be discussed. The first is the role of the rentalsman. The second are the obligations of landlords and tenants. The third are security deposits and leases. The fourth are notices and evictions. The fifth are the 5 steps to solving any issues. And the last are additional resources. The role of the rentalsman. The Office of the Rentalsman is an administrative tribunal, and our role is to enforce the New Brunswick Residential Tenancies Act. The Office of the Rentalsman does not advocate for either tenants or landlords. We are an unbiased third-party entity to help an applicant on issues relating to the law. Some of the services may involve investigating complaints, or providing mediation services, or administering tenants' security deposits, or even adjudicating any disputes. The landlord's obligations. The landlord has an obligation to keep the premises and chattels clean, in working order, and fit to live in. Chattels is a term used to define a landlord's or tenant's personal belongings. For example, if appliances or furniture are included in a rental property, those would be considered the landlord's chattels. Personal belongings brought into a premise by a tenant are considered the tenant's chattels. The landlord must comply with all health, safety, housing, and building standards and any other legal requirement. The landlord must also ensure all common areas are clean and safe. The tenant's obligations. First and foremost, a tenant must pay their rent on time. Tenants must keep their place clean. Tenants must also repair any damage caused by willful or negligent conduct of the tenant or any of the tenant's guests. Tenants must also avoid causing any disturbances or being a nuisance. Security deposits and leases. Landlords do not have to request a security deposit, nor do they have to get a lease signed. However, if a tenant provides a landlord money in exchange to live at the premises, this tenancy is still covered by the Residential Tenancies Act. If a lease is signed, it is very important to read the details of the lease. There is information related to when a lease starts, ends, gets renewed, and what services are provided within the agreement. If a security deposit is collected, by law, it must be remitted to the government within the first 15 days. The tenant can remit the security deposit at any Service New Brunswick Centre, or the landlord may remit it on behalf of the tenant. When a security deposit is remitted to the government, a tenancy is created in the government computer system. Both landlord and tenant receive a confirmation that the security deposit has been received and are provided with a tenancy number. It is important to retain this tenancy number for any future correspondence with the Office of the Rentalsman. The security deposit is owned by the tenant, and the Office of the Rentalsman holds it in trust. However, at the end of a tenancy, a landlord may submit a claim against a portion or the entirety of the security deposit. Some common reasons for a claim would be for repairs, for cleaning, or for unpaid rent. Evictions and termination process. Landlords do not evict tenants. Only a rentalsman can evict. If rent is not provided on or before the day it is due, a landlord can serve a tenant with what is called a notice to vacate the day after the rent is due. The tenant then has 7 days to pay the rent in full, or will have to vacate the premises within 15 days. If a tenant does not vacate the premises, at that point, a rentalsman can issue an eviction order and have a sheriff remove the tenant, allowing the landlord to regain possession of the premises. A notice of termination is served when either party decides to end a tenancy. For example, in a month-to-month tenancy, a tenant would have to give at least 1 calendar month's notice to their landlord that they are not going to renew their lease. No reason is needed. The same goes for the landlord. The landlord can provide the tenant with a month's notice to end the tenancy and no reason is needed. The notice of termination has to be in writing, be dated, be signed, indicate the premise and the person to whom it is addressed. In another example, in a year-to-year tenancy, the notice of termination has to be served at a minimum 3 calendar months prior to the end of the tenancy. Please note that the 3 months notice is prior to the end of the tenancy and not 3 months at any time during the tenancy. If a notice is not served within those 3 months before the end of the tenancy, the year-to-year lease automatically renews for a new year. The Office of the Rentalsman can actually review a notice of termination if either party has any questions regarding it. The 5 steps to resolving any issues. These 5 steps apply equally to both tenants and landlords. Given the target audience here are tenants, I will speak in terms of how a tenant would approach a situation with their landlord. Number 1. The first step is to have a discussion with your landlord. Quite often, if the landlord is aware of a situation, they will address it and resolve the problem. If that doesn't work, and the landlord does not address the issues raised by you, step 2 is to put in writing the issues and ensure it is dated, signed, indicates the premise, that it's addressed to your landlord, and that it highlights the issues you would like addressed, and has a time frame, which is usually about 1 week, for the landlord to address the issues. When you serve your landlord with this letter, please keep a copy for yourself as well. If the issues raised at step 2 are still not addressed by your landlord, then you may go to step 3. At step 3, you can apply to the Office of the Rentalsman for assistance. Please note that the Office of the Rentalsman will be asking for a copy of the letter you served to your landlord in step 2. Depending on the details of the case, mediation may be attempted in step 4. If mediation is unsuccessful, adjudication may occur. The rentalsman's decision can be appealed at the Court of Queen's Bench only if there was an error in law or that the rentalsman did not have jurisdiction. Additional resources. Additional information regarding the Office of the Rentalsman is available on the website at www.snb.ca/irent. Email inquiries can also be sent to irent@snb.ca. Telephone calls can be answered by calling our toll-free number at 1-888-762-8600. Thank you.